Good afternoon. We'd like to welcome you to this afternoon's program, Dobbs, Historical Context and Future Implications, sponsored by the Women in Law section and the Committee on Continuing Legal Education of the New York State Bar Association. If you're not a member of NYSBA or the Women in Law section, feel free to visit our website for more information on how to join. Today's program will run from 12 p.m. to 1:30 p.m. And during the course of the program, if you would like to pose a question to any of the speakers, you should use the Q&A function in the Zoom portal, not the chat function. At this time, it is my pleasure to introduce the chair of the Women in Law section, Cheryl Galler, for some opening remarks to get us started. Cheryl?
Thank you so much, Ernesto. Thank you for everyone who's joining us today. And of course, thank you to our moderator and speakers. Allow me to say a few words about the Women in Law section. We have over 600 members, women and men, throughout New York and throughout the world. We are dedicated to addressing critical issues that impact attorneys and also impact all women under the law. So issues that we address that impact you as attorneys include your career development, networking, and leadership skills. And issues that we address under the law include paid leave, equal pay, sexual harassment, voting rights, the needs of underserved populations, and of course now reproductive rights. We have more than a dozen different committees, which means more than a dozen different ways for you to get involved. And some of those committees include our annual meeting and programming committee, the one that is putting together today's program. We have a really popular book club. We have one coming up in September. We have our Women on the Move program that will be in October. We have the annual meeting in January, and we have a whole bunch of other programs that we run throughout the year. We have an emerging lawyers committee for emerging lawyers, and we have a mentorship program through that committee. And we have a legislative affairs committee, which analyzes and evaluates proposed legislation that affects women and all people under the law. And our committee has had a real world impact on laws that are passed in New York State. So we invite you to take a look at all our different committees and see the ways that you can get involved. If you're not yet a member of the Bar Association or our section, we certainly encourage you. We also present 2 awards to our leaders in our profession, the Ruth G. Shapiro Award and the K. Crawford Murray Award, which recognize trailblazers. And we have a journal, Wills Connect. Our summer edition is at the printers right now, but we will be working on our winter edition. And so if you'd like to write any articles, make any contributions, we're certainly welcome you to do so and get in touch with us, and we will work with you on that, and it's fantastic. So we are really very excited to present today's program. Today is actually the second program in the past week that we have presented on the changes in reproductive rights and healthcare. Last week we talked about state law issues, and we had representatives from the New York State Attorney General's Office Task Force. And today we have Catherine Weiss and Professor Catherine Franke, who will be talking about national and constitutional issues with us. We are planning additional programs on the Dobbs decision and reproductive rights. And we do recognize that the decision and the rights affect different communities and different people from different backgrounds in different ways. And so we are looking to address all of that. And we're also looking to address the different ways that areas of the law are affected by the decision. So if you are an expert in the area or you know someone or you'd like to be on a panel, certainly reach out to us. We're always looking for panelists and presented programs that are of interest to our members. You can take a look on our website, which I know Ernesto has the slide up. Thank you so much. We have issued a statement on behalf of the Women in Law section regarding the Dobbs decision, and our statement is there. And information about our programs and future programs is also on our website. If you're a member of the section, you'll also receive our emails through communities, and you'll also receive emails from the Bar Association and weekly e-blasts that they send out regarding different upcoming programs. So take a look at all of that. And again, if you have any questions, if you'd like to get involved in any way, please feel free to contact me or anybody from the section, and we'll be very happy to work with you. So we do invite you to get involved. So it is now my pleasure to introduce the moderator for our program today, Jennifer Delgado. Jennifer is a partner at Lowenstein Sandler, where she maintains a robust litigation, investigations, and counseling practice in which she services a diverse client base, from multi-billion-dollar asset managers to multinational cosmetic companies. In 2020 and 2019, Jennifer was recognized on Crane's list of notable women in law, New York, for her distinguished legal career and contributions to civic and philanthropic activities impacting New York City. Jennifer is also deeply committed to pro bono work, and her passion for justice extends to her commitment to advancing the role of women in the legal profession, as well as improving diversity generally. Jennifer also chairs the Partners Committee of the New York State Bar Association Women in Law section, so I get to work with her on that, which is wonderful, and we really appreciate her efforts and her work and her commitment to the program today. And so Jennifer, I now pass the virtual microphone over to you.
Thank you so much for that, Cheryl. Just a plug, please, if you're interested in joining the Partners Committee, please reach out to me by email after this program, and I'd be happy to speak to you about that. This is my absolute pleasure to moderate this panel and to introduce you to our wonderful speakers today. First, we have Professor Catherine Franke. Professor Franke is the James L. Dorr Professor of Law at Columbia University and Director of the Center for Gender and Sexuality Law. She is among the nation's leading scholars writing on law, sexuality, race, and religion, drawing from feminist, queer, and critical race theory. Professor Franke is also the founder and faculty director of the Law, Rights, and Religion Project, a think tank based at Columbia Law School that develops policy and thought leadership on the complex ways in which religious liberty rights interact with other fundamental rights, which is, of course, of interest today on the topics today. In 2021, Professor Franke launched the ERA Project, a law and policy think tank to develop academically rigorous research, policy papers, expert guidance, and strategic leadership on the Equal Rights Amendment to the US Constitution. I'm also pleased to introduce to you my partner, Catherine Weiss. Catherine is a partner at Lowenstein Sandler and the chair of the Lowenstein Center for the Public Interest. Under Catherine's direction, the Center for the Public Interest has expanded the firm's historic commitment to public service by building an award-winning program that serves hundreds of low-income individuals and the nonprofit organizations that support them. Catherine is a lifelong public interest lawyer with a strong commitment and track record in the area of reproductive rights. She previously served as director of the Reproductive Freedom Project in the National Office of the ACLU. She also served as director of the Division of Public Interest Advocacy in the New Jersey Department of the Public Advocate, as well as deputy director of the Democracy Program at the Brennan Center for Justice at NYU Law School. Thank you both for being here. I know that your schedules have been jam-packed with a lot of interesting programs such as this one, but of course, the topic is not a happy one for many of us. For me, and I said this to the speakers before we started, I couldn't believe that it had only been 3.5 weeks since the decision had come down. It was for me not a surprise. I've been worried about this for many years now. And still, even with the draft decision leaking and reading it for myself, many weeks ago, I was shocked. June 24th was a very difficult day for me, and I know for many others. And I really appreciate your time because I think it's very important to really understand the context and the implications of this decision. And that's exactly what we'll be doing today. And just for the benefit of the audience so that you understand the format, we're going to first start by going through the decision and really having Catherine Weiss walk us through the decision, the concurring opinions, the dissent. And then Professor Franke is going to jump in and she's going to talk to us about how we got here from Roe. How is it that we got here? And that's, somewhat of an existential question, but also a legal question. And that's what Lens will be looking through. And so I want to jump right in. I don't want to waste too much time because we have a lot of ground to cover. I'll just say for the audience, if you have a question, please do put it in the Q&A function. I will be monitoring that throughout the program. It may be that a question that you're asking will be covered later in the program. And so I may skip around a little bit, but I will jump in and ask the panelists to answer your question if I think that it's appropriate at that moment. Once we go through the decision and the context that we just described, we're going to go into a Q&A portion in which I'll be reading off questions that have been predetermined, and hopefully I'll be covering all of the burning questions that you have. But without further ado, Catherine, can you start us off and can you give us high level or in as much detail as you think is appropriate to give us context for this discussion today?
Thanks, Jen, of course. So I'm gonna summarize this decision. And I just want to start by saying I am not neutral. I obviously have very strong views on these opinions. And I, unlike Justice Kavanaugh, don't have a lot of interest in pretending to be neutral. So I wanted to say that sort of as a caveat at the beginning, but I am going to try to describe what the justices have said as accurately as I can. So here are the facts. Mississippi passed a ban on abortion after 15 weeks gestation. Jackson Women's Health Organization, the only abortion clinic in the state of Mississippi, sued to invalidate the ban. The federal trial court and the Court of Appeals invalidated the ban because it prohibited abortions before fetal viability, which was the line drawn in Roe v. Wade and Planned Parenthood v. Casey. Mississippi petitioned for review in the United States Supreme Court, which heard arguments last December. And on Friday, June 24th, the court upheld the Mississippi law and overturned Roe and Casey and all of the related abortion precedents. The decision has 5 opinions. Justice Alito wrote the majority opinion, joined by 4 other justices, Thomas, Gorsuch, Kavanaugh, and Coney Barrett. And so we'll start with the majority opinion. The majority opinion begins with a discussion of due process. It notes that abortion is not mentioned in the Constitution, and yet it says if it is protected at all, it is protected as a matter of substantive due process. The majority flatly rejects an equal protection argument for abortion rights on the ground that, and here I'm quoting, a state's regulation of abortion is not a sex-based classification and is not motivated by, quote, invidious discrimination against members of one sex or the other. This is an old line of reasoning. It comes from a case called Geduldig versus Aiello in 1974, which upheld a statute that denied disability benefits related to pregnancy. Again, then on the grounds that pregnancy discrimination was not sex discrimination, oddly enough. So then having rejected an equal protection argument out of hand, the majority turns to substantive due process. And you will all know that substantive due process is the constitutional provision, that the principle that underlies the protection of certain kinds of personal and defining decisions, including how best to raise and educate your children, whether to use contraception or to agree to sterilization, whom to live with, whom to marry, whether to refuse surgery, decline drugs, refuse life-saving medical treatment, and so on. The court says that when deciding whether a right is protected by substantive due process, the court must ask whether the right is, quote, deeply rooted in our history and tradition and essential to our nation's scheme of ordered liberty. That is the due process test that the court articulated. Applying this test, the court concluded that due process does not protect abortion rights. And that is because of a number of reasons. I will outline 3 of them. This is a historically based argument, and it begins like this. Neither the English nor the American common law protected the right to an abortion. There's actually dispute about that, but the court says that it did not. The court also says that American states banned abortion by statute, which is, of course, undoubtedly true. The issue is about that is when. Most crucially, the court relies on this. By 1868, when the 14th Amendment was ratified, 28 of the 37 states existing at the time, 3/4 of them, criminalized abortion at all stages of pregnancy. Of the remaining 9 states, all but 1 criminalized abortion by 1910. It was, in fact, the mid-19th century that saw these criminal bans adopted in the United States. Given the widespread bans in the mid-19th century, the drafters of the 14th Amendment cannot have thought they were protecting the right to abortion. the majority notes. And that is why Roe was, this is their language, you will have seen it in the papers, egregiously wrong from the start. As to whether they should nevertheless bow to stare decisis, the court wrote that it must be able to correct constitutional errors, as others cannot step in to correct them, right? The court is the final arbiter of the meaning of the federal constitution. So it must be able to correct constitutional errors, especially when the original decision was wholly wrong to begin with, as they thought Roe was. The precedent was badly reasoned, as they also thought Roe was. The precedent is unworkable, meaning that the standards, the undue burden standard, the more specific standard outlined in Roe, they view these as standard list and unjustified and unworkable in real life. The precedent distorts other areas of law, which they thought this line of cases did. And finally, that when there is no reliance on the precedent, the court views itself as free to correct it. And the majority viewed it as impossible to assess the effect of the abortion right on society, and in particular on the lives of women. And therefore it could not find any clear reliance interest. Now, as to what other rights would be affected, the majority opinion says over and over again that abortion is a unique act because it terminates life or potential life. It says, in conclusion, our decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. So the majority makes a very loud play on the idea that it is affecting only abortion rights through this decision. Now, Chief Justice Roberts writes a concurrence, and his concurrence would uphold the Mississippi law, but leave the decision whether to overturn Roe to another day and to a case where it is more squarely presented. In other words, Chief Justice Roberts would uphold a ban following after 15 weeks of pregnancy, but would not have decided whether Roe should be overturned altogether. Justice Thomas writes a concurrence, and he, of course, goes wholesale in the other direction. He writes that substantive due process has no constitutional basis in general, and calls for all the decisions resting on this foundation to be overruled, quote, at the earliest available opportunity. So he would bring down the whole substantive due process lines of cases, and that includes, as I mentioned, many areas of law, from bodily integrity to family, to the creation of families, to marriage. Many, many things come under the doctrine of substantive due process. Justice Kavanaugh writes a concurrence. And Justice Kavanaugh's concurrence is really an attempt to argue that the decision in Dobbs restores the Supreme Court to a position of neutrality. He says that the court is neither pro-life nor pro-choice. It takes no position and returns this question to the legislatures. He also casts doubt, as an aside, on whether a state may bar a resident from traveling to another state to obtain an abortion, and he says that that is not constitutional because of the right to travel. Now, Justices Breyer, Kagan, and Sotomayor write a dissent. And their dissent starts with something that is wholly absent from the majority opinion, and that is the assertion that abortion has an effect on women, right? They begin with discussing what the effect of an abortion rights decision or its reversal has on the lives of women and other pregnant people. They criticize the majority for for their failure to respect a woman as autonomous being, for granting her equality, for not being able to see that this means giving her substantial choice over what they call this most personal and consequential of all life decisions. The majority explicitly attacks, the dissent explicitly attacks the majority in that it would allow states to ban abortion from conception onward, I'm quoting, because it does not think forced childbirth at all implicates a woman's rights to equality and freedom. Today's court does not think there's anything of constitutional significance attached to a woman's control of her body and her path in life. So again, this is where the dissent picks up and really, really does attack the majority for ignoring women and pregnant people. It then defends Roe and Casey. The majority had said that the dissent showed no respect, and that Roe and Casey, in effect, showed no respect for potential life. And the dissent says this is entirely incorrect. It notes that Roe and Casey balanced the right, the state's interest in potential life against women's health and women's rights by allowing bans after viability, except to preserve a woman's life or health, and allowing significant restrictions before viability. And I will say that anyone who's done abortion rights work over the past 50 years knows that significant restrictions exist all over the United States, have existed for decades. The dissent then ties the right to reproductive autonomy to other important rights, other important civil rights, and to precedent. And it begins by noting that civil rights and individual rights in the United States are not subject to majoritarian rule. They are rights against the majority. The right to free speech is not controlled by legislatures. The right to worship is not controlled by legislatures. These are things preserved to individuals as against the will of majorities. And they state that this right should be such a right, and that therefore it is not neutral, as Justice Kavanaugh put it, to leave everything up to the states. Rather, the court acts neutrally, the dissent says, when it protects individual rights against all comers. As to substantive due process, the majority concedes in very plain language as follows, quote, in 1868, there was no nationwide right to end a pregnancy, and no one thought the 14th Amendment provided one. So they concede that in 1868, there was no right of reproductive choice in the United States. And then they say that is not the controlling question. They begin by noting that in 1868, women were not conceived of as part of the people who governed the land. They did not have the right to vote. They could not serve in legislatures. They were not part of the community, the dissent says, embraced by the phrase, we the people. So when the majority says we must read the Constitution as the ratifiers read it in 1868, they consign women to second-class citizenship. Instead, the dissent writes the Constitution is a living document meant to apply to changing circumstances. Interracial marriage and same-sex marriage were both crimes at the time the 14th Amendment was ratified. Contraception was illegal, but no more. They note that the fact that the views of the ratifiers should not control doesn't mean that there is free reign to do whatever you want. Instead, they say that fundamental rights are based on constitutional principles, constitutional history, and constitutional precedent, like the ones that supported Roe and Casey. The court's precedents on bodily autonomy, sexual and family relations, and procreation are all interwoven and part of the fabric of our lives. Bodily autonomy, they use as a particular example, and they note that everyone, including women, owns their own bodies, and that there are few greater incursions on a body than forcing a woman to complete a pregnancy and give birth. As to the slippery slope problem, they say no one should be confident that the majority is done with its work. They note what they call the sort of baseline hypocrisy in the opinion. Here's what they say. Either the majority does not really believe its own reasoning, or if it does, all rights that have no history stretching back to the mid-19th century are insecure. Either the mass of the majority's opinion is hypocrisy, or additional constitutional rights are under threat. It is one or the other. So that is a summary of the opinions, and I think we should move on from there.
Well, we're gonna pick that back up in a second, Catherine. But before we do, Professor Franke, can you just explain to us how we got from Roe to Dobbs? And you can sort of take it with whatever lens you think is appropriate, because I do think that there is an existential question there. But from a constitutional standpoint, what happened in almost 50 years that could change the landscape so drastically?
First of all, I just want to thank you for inviting me to be part of this discussion, as grim as it is. But we need each other in this time to figure out where we go next. And Catherine just did an amazing summary of a really complicated set of opinions. The ecology of those opinions and how they are and are not speaking to one another, I think, is also worth its own webinar. But that was really masterful. Thank you, Catherine. You know, part of why we are where we are today, I think there are many reasons, right? One is the right secured in Roe was never the right that feminists were seeking. There were many arguments made in early litigation that predated Roe about why we ought to have access to the full range of reproductive health care as a constitutional matter. You know, the litigation in New York State that predated Roe previewed a set of arguments that turned not only on issues of women's equality, sex-based equality, but liberty, bodily autonomy. Even, you know, I teach a manifesto issued by a bunch of feminists in Connecticut in the late 60s, where they also saw restrictions on abortion as being a violation of the 13th Amendment, as a kind of involuntary servitude of conscripting your body by the state into a kind of labor, literal labor, of producing children. And for that reason, I stopped talking about these new measures as being about that they're anti-abortion in nature, but that they compel forced birth. And I think, and childbirth, and Catherine used that term earlier, and I know she does so deliberately. And I think we need to also change our language about, in a way that repoliticizes and brings to the fore what's really at stake in these cases. And so being pro-choice as opposed to anti-choice, I think occludes what's really at stake. So Roe secured a right of privacy, but not even one that singularly resided in the pregnant person, but the pregnant person and their doctor, who in the early 1970s was presumed to be a man. So there was already a man on the scene who was a sort of co-tenant of this right. And while it was wonderful to win the decision in Roe, it's not that those of us in the feminist community were thrilled with the reasoning. And so our work since then has been to defend a principle that we weren't fully invested in. We were certainly invested in the large idea of it, but not the specifics of it. And to privatize something as important as what we could say is sexual equality, reproductive autonomy, you know, a wide range of other ways of thinking the problem, is to say that there's no public responsibility to be a kind of custodian of that right. And of course, the litigation that followed Roe included claims that poor women should have a public right to funding for abortion, but resting the right in privacy doesn't give you much to then leverage in order to say that there is a public right to funding for this fundamental part of not just reproductive health care, but citizenship. And so we lost the challenges around public funding for abortion. The Hyde Amendment came in, was passed by Congress almost immediately after Roe, saying that there couldn't be any public funding for abortion. And then states, of course, could opt in or out of public funding. And so it turned on what state you lived in terms of whether there might be public subsidies for access to abortion. And then as Catherine mentioned, we had Godalvig a year later and Gilbert. There were two companion cases that asked the question of whether pregnancy discrimination under the Constitution and also under Title VII amounted to a form of sex discrimination. And the Supreme Court famously and horribly said no. There's no relationship whatsoever between sex-based inequality and pregnancy discrimination. And again, reifying or ratifying what in some ways was a loss of principle that we won in Roe, to not be able to connect the dots from abortion, pregnancy to sex discrimination. It was just a disaster politically. I'll also say that the right mobilized so effectively in response to Roe over a period of time in a way where we were playing defense against these increasing restrictions on access, regulations of providers, restrictions in terms of time limits, the consent for either for parents or for the other partner who might have been involved in creating the pregnancy, having to look at images of fetuses, read wrong stuff about fetal pain, a whole range of things. And the right was extremely creative and effective in undermining or hollowing out the right of Roe from the very beginning. Casey reaffirmed to some degrees and altered a little bit the holding in Roe, but the primary value that was at stake in Casey was stare decisis, not reproductive freedom or equality. In that decision, the court said, look, people have come to rely on this decision. The court's integrity is at stake here, that we can't just flip our position in such a short period of time. And so the legitimacy of the court loomed more heavily in Casey than did the underlying question of the constitutional right that was at stake. And what we've seen happen in that time since 1973 is the right successfully arguing over and over and over again in a way that I think we all thought, well, this won't go anywhere. Well, ultimately it did, which is that Roe was not real constitutional law. It was the court overstepping. And the culmination of that argument is what we see in Justice Alito's decision in Dobbs, which is that there are real constitutional rights, and those are ones that we see grounded in the text of the Constitution and or in evidence in the history of what either from 1868 or if you read some of the other court's jurisprudence from this term going back to 1791, where there's a history and tradition of recognizing this right. That's real constitutional law. Those are what I think we can safely term our first tier constitutional rights. Religious liberty, gun rights, and property rights really are the messages we've gotten from this court in the last couple of years. Other rights that might lie in the court's jurisprudence of substantive due process are absolutely on the cutting block now. And I think Catherine described the dissent's critique so well, that this turn to history, text, if you've got text, that's great. If you don't, then you look at history, notwithstanding the fact that the rights holders were not full citizens or citizens at all. In the case of Black people, weren't even people in many parts of the country at the times that the courts are looking into this important history. Those rights are quite vulnerable now. And to the extent that Justice Kavanaugh says in a way, ladies, don't worry, you've got the right to travel. Well, the right to travel doesn't appear anywhere in the text of the Constitution either. it's also as squishy a right as the other substantive due process rights. So I think we have much to worry about in terms of the right to travel, and certainly Obergefell, Lawrence, Eisenstadt, all of those cases that rested on a very similar set of arguments around substantive due process. We can always count on Justice Thomas to say the quiet part out loud, and he sure did in his dissent. And in a way, he's giving the to-do list to the right wing of the court. All right, we're starting here, but here's where we go next. So they're just getting started. One last thing I'll say is that the day after Obergefell was decided in 2015, there was a press conference and a panel at the Heritage Foundation. And one of their resident scholars, first thing out of his mouth was, we're going to give Obergefell the Roe treatment. That means to not treat it as real constitutional law, to treat it as the court legislating from the bench, making up a right that doesn't exist in the Constitution. And we're going to bring every religious liberty challenge to Obergefell that we possibly can, because we've tried it and it's worked so well in the abortion and reproductive rights context. And that is what they've done with Obergefell, and I would say not unsuccessfully. So they connect the dots between these decisions, and they now have a court that is connecting those dots as well. Stop there.
Thank you so much, Professor Franke. I think that's actually a good segue into my next question, and that goes to Catherine. We've spoken a lot so far about these substantive due process decisions that are at risk. Can you talk about which ones you see coming up first? I mean, what are the challenges that are being brought right now, and what do you think is most vulnerable, if there's an answer to that? You know, I think it's of grave concern to many of us that this is not the end of the story, but for someone who's not a constitutional law scholar like myself, I am sort of focused on trying to understand what the real world impact of this is, and, you know, what's the first up?
You know, as Professor Franke said, I don't know that there is a first up. Many things are up and have been up for a while already. I would say that, you know, one of the things that's interesting about the majority opinion in Dobbs is how very thoroughly it relies on an opinion called Washington v. Glucksberg, which was a decision in the 90s. I don't remember exactly the year, but in any case, it said that there was no federal constitutional right to end one's life, to assistance from a physician in ending one's life when one had a terminal illness and was in great pain. And I remember, I was at the ACLU when Washington was decided, and I remember reading it and thinking, this is the decision that they're going to rely on when they overturn Roe. And indeed, that is the decision they relied on when they overturned Roe. And that is because there's such a very strong relationship between the right to avoid forced pregnancy and the right to avoid being forced to continue your life when it has become unbearable to you. And other rights involving bodily autonomy. And so, you know, when I first got to the ACLU, there'd been a spate of cases that were forced cesarean section cases in which the state had decided for one reason or another that a fetus was at risk and went to court. This was typically religious hospitals that went to court to get orders to require the pregnant woman to have a cesarean section. And incredibly, in my view, a number of courts ordered this, even though the standard rule in American law is that we don't force people to undergo surgery or other medical procedures against their will. So just like take a step back, and I'm just going to talk about one of the little paradigms that abortion rights lawyers talk about a lot, which is, suppose your child, your living child, were dying from kidney failure. could an American court order you to donate your kidney if you had a match? Answer, of course not. You would do it. You would probably do it because you'd want to save your child's life, but you couldn't be ordered to do it. Just as you couldn't be ordered to provide continual life support to keep another living person, including your living child, alive. And yet, these decisions stand for the proposition that you can be ordered to continue to provide complete life support to a not yet born child of yours. And so I will start with the one that has been at grave risk for a long time is the concept of bodily integrity and autonomy, that I will decide what is done with my body and you will not decide for me what is done with my body. Those rights are gravely at risk and have been for some time. And then obviously all of, contraception, I'll go there second. Contraception's been under attack in a way that has really surprised me for some time. I would have thought that in 2022, we'd be beyond the point at which we worried terribly about people having to provide health insurance coverage that covers contraception in ways that conflict with their religious views, because it's not up to them, right? It's not up to them, it's up to the patient in question. But no, we've had big fights and we've lost them about whether contraceptive coverage can be required in federal law. So contraception, I think, is at risk. And then all of the LGBTQ rights, as Professor Franke noted, right? Same-sex marriage. This is one that I think Professor Franke is better able to address than I am, because I feel like culturally, there's a big difference in some ways between that and some of the other rights. That there attacks on same-sex marriage are transparently attacks on our neighbors and friends, whereas the court and the right have dissociated abortion from the people carrying the pregnancy in a way that makes attacks on abortion seem like they are not attacks on women. And there are other things too, right? In the politics of this debate, the fetus has become the symbol of vulnerability and innocence and the repository of compassion on the right. And I dare say, as a policy matter, the only one, right? It's not like there are other places to hang that hat. They're against welfare spending, against spending on public education, for the death penalty, for gun rights. It's not a compassionate looking platform, except for the fetus. And that has also distinguished the politics of the abortion debate from other debates, because it has become the symbol of everything that we should protect. I think in the hierarchy, it's hard to know. There'll be attacks on all of it. It's hard to know how they'll come out. But Professor Franke may want to weigh in on that.
Well, I think it's, before we started, I don't even know where to start. Before we started this webinar, I felt like I had to read the news every minute, because there's so many new bills being introduced across the country on such a wide range of issues. Some of them would amend the state constitution, some of them would just add new legislation. So it's a very quickly moving landscape. And the right is enormously good at stepping on the accelerator after a win and building on that win immediately in a way that I think we could also learn from. The thing about same-sex marriage, often people say there have to be lessons for other movements about how we won marriage rights. In a pretty short period of time. It would happen much faster than I thought it would. But what differentiates marriage, I think, from abortion is it's something to celebrate. It's, you bring your family together, your friends, it's a party, it's about love, it's about lots of things that are positive. And abortion, you know, whatever you want to say about it, it's something I think you'd rather not have. It's not a pleasant thing to talk about. It's not a pleasant thing to experience. It's not a pleasant thing to have to undertake. And so it's just a very different ethos of a communication strategy around this right, which is necessary, absolutely, for a whole range of reasons. I didn't think marriage was actually necessary for the gay community. In fact, I wrote a whole book about why it wasn't necessary, but it was an easier thing to sell. And I would say, and I've said this many times before, I regret that the gay community did not feel obliged to help benefit the reproductive justice movement through the arguments they made to secure constitutional rights in Lawrence and Obergefell. The politics, the LGBT politics, I came out in 1977. That was a sexual rights movement, right? Lesbians saw themselves very much in community and politically aligned with straight feminists working on reproductive rights. Gay men, not so much. But as time progressed, the gay rights movement turned into a marriage rights movement. And part of why we were successful, I think, so quickly is because we drained the sex out of homosexuality and turned it into being about family and love, which I'm not against family and love either. But what we did is we created a separate communications and legal strategy that was working for our community, and we left reproductive rights and other kinds of sexuality behind rather than seeing them as part of a whole. And I regret that. I think it was a strategic mistake. I think if we had one Obergefell in a different kind of way and one Lawrence in a different kind of way, we might not be in as dire a situation as we are now around reproductive rights, around non-homosexual sex. And it's an odd thing that we look at the Constitution and same-sex sex is in much better shape than different sex is. But that isn't to say that this isn't a fragile place that we're in, because I do think that they're coming for us too.
Yeah, that's interesting. And in particular, the sort of gestalt around abortion versus marriage, right? I agree, right? Nobody celebrates abortion, but I will say that one of our problems, I think, historically, is that we talk about abortion as if that's the bad thing, when the bad thing is unintended pregnancy. Abortion is what helps solve that problem. The problem is that people get pregnant and don't mean to. And that problem we also, of course, have to solve if we mean to get beyond the station we're in.
Thank you both for that. I want to turn back to the potential impact on reproductive health care, other than in the area of contraception. And I'll pose a question that was raised by a member of the executive committee for the Women in Law section, because I think it's an interesting way to look at the question generally. We are hearing stories in the news about women in childbearing years who live in states that ban abortion, who have been denied prescriptions for medications for conditions, for example, rheumatoid arthritis, because the medications might cause abortions. Are these isolated cases, or are there real concerns that the impact could be far-reaching past contraception? And I originally envisioned this question for you, Professor Franke, but please, both of you jump in. I think it's great to have a back and forth on these questions.
I will clarify for everybody watching that we're calling me Professor Franke because we're both Catherines. So I'm not insisting on that formality. And I feel sort of funny about it because I hold Catherine Weiss in such high regard that I don't want to create the wrong impression here. One thing I want to know, and if I could ask, I'd shared a link on the chat with the folks putting on the program today, if you could share that with everyone. We did at the Law, Rights, and Religion Project a 2-year comprehensive study that we released just a little while ago on Southern hospitals. We wanted to see how the religious affiliation or religious climate in which hospitals in the South were operating impacted reproductive health care, but also gender affirming health care. We'd earlier done a report on Catholic hospitals, which was much easier because the Catholic Church, it issues missives that apply to every Catholic-related healthcare setting. But Protestants are much more difficult to study because the Baptists and the Methodists and the Seventh-day Adventists and all the hospitals that we have throughout the South don't have an affiliation with a mothership that sets the policy. They kind of set their own policy. So we did this in-depth study pre-Dobbs to see what reproductive health care looked like in a climate where there either was an official religious affiliation of a hospital or in a community with very strong faith-based views around religion, around abortion. And of course, what we found was not only was abortion and other forms of reproductive health care, sterilization, a whole range of things, just D&Cs, vasectomies for men, were not available in virtually every religiously affiliated hospital, but even in secular hospitals that did not have a religious affiliation, the climate, a hostile climate around abortion, largely framed in religious terms, meant that even secular hospitals were basically abiding by religious limitations on access to reproductive health care, unless the health of the woman was at stake. But what we saw was that you had to be actually dying, actively at the end of life. Death had to be imminent. And even in those cases, not always, was the termination of a pregnancy seen as permissible under the hospital's regulations. So that cancer treatment, rheumatoid arthritis treatment, a whole range of treatments that were part of non-reproductive health care for many, many people were denied to those who became pregnant because it might negatively impact a fetus, thus immiserating and increasing the risk of death for those pregnant people who had cancer, had other kinds of conditions. So I mentioned this report to say, this situation we're in now has been the situation in many parts of this country for quite some time, particularly for low-income women of color. So, Dobbs was not an on-off switch. Maybe it isn't our popular discussion about it, but many people in this country have been living with this situation where they've been denied essential health care that it was independent of their reproductive health care because of the protection of the fetus, and they have died because of it. Not just the possibility of their death, but we uncovered so many examples from reproductive health care doctors, nurses, doulas, and others in the South who said, I have had so many patients pass away because they didn't get the critical care that they needed because they were pregnant, even in secular hospitals. So I would encourage you to click on that link that we've dropped into the chat of our Southern Hospitals report that goes into this in great detail. And we have some just riveting interviews with people who have been and were horrified by what it looked like to deliver reproductive health care, and along with all the other healthcare people need pre-Dobbs.
And sorry,
Jen. I'm just going to jump in there for a second because I do think that this kind of thing is viewed as hyperbolic. And I just want to say, if you'll indulge me, I'm going to tell you a very little story. So I'm sitting in my office in the ACLU in, I think it was 94, and I get a call from a doc in Nebraska. And the doc says to me, I've got a patient, she's 19. She was brought into the hospital unconscious because she passed a blood clot to her lung. And she is 9 weeks pregnant. We did the test when she was admitted. She's 9 weeks pregnant. And the clotting disorder is related to the pregnancy. That is a rare, but not very rare, complication of pregnancy that some people create blood clots. The doc says to me, I and 3 other doctors at the hospital have certified that she needs a life-saving abortion, because if she throws a blood clot to her lungs or brain, she could die instantly. She didn't die with the last one that went to her lungs, but she became unconscious and was at grave risk. And they had disintegrated the clot with lasers and other technology, medical technology. So 4 docs certify that it's a life-saving abortion. And the hospital council said, religious hospital council says, no, we won't do it. The hospital's alternative plan was to keep her in the hospital for the remainder of her pregnancy. Remember, she's 9 weeks pregnant, so she's looking at 7 months in the hospital. She has a 2-year-old at home. She's 19. She's African-American. And they were going to keep her in traction so that if she threw blood clots, they would go up to her feet instead of to her heart, brain, or lungs, and keep her on blood thinners, which were intravenous only at the time, the ones that were safe for the pregnancy. So they were going to keep her in the hospital for 7 months. She said, what with being now conscious, no, I have a 2-year-old at home. I want you to terminate so I can go home and take care of my kid. And the hospital refused. But now she's trapped, right? She's in a hospital and she's trapped. She's not supposed to be moved because she's throwing blood clots and they can be dislodged by movement. So I get on the phone with hospital council. We start having the conversations you can imagine we're having. We're going to sue you, yada, yada, yada. Meanwhile, the docs are freaking out. And finally, I will tell you what happened with this young woman is that she agreed, they advised, and she agreed to be moved on a gurney into an ambulance, driven half an hour, wheeled into a clinic where they did a first trimester abortion, and then sent back to the hospital for follow-up. And everyone agreed that this risked her life, including her. But she was completely unwilling to take the chance of remaining pregnant and in the hospital for 7 months on blood thinners and in traction, right? And that case, I said to myself, like, what is happening, right? And the fact that Professor Franke's study uncovers that this kind of thing happens all the time makes me want to shoot. I mean, it's incredible to me that we are still playing Russian roulette with the lives of pregnant people like this. And so I just want to emphasize these things are real. I mean, people in our bubbles don't believe it, but these things actually happen. So with that, the next question.
I'm gonna move past this topic. I was going to ask about IVF and the potential consequences there, but we'll circle back to that if we have time. I wanted to switch gears a bit and talk to Professor Franke or Catherine with a K, whatever your preference is, on the intersection between religious rights and these bodily autonomy cases that we're talking about. I think it's an interesting area because, you know, I've read, and I'm sure many of us have also read the same things about a synagogue in Florida filing a lawsuit against the governor of Florida for essentially choosing one religion over another, or at least violating the Constitution, which prohibits the penalization of someone for practicing their religion. And of course, in the Jewish religion, it is not a violation of religious principles to obtain an abortion. And so I find this to be a very interesting area. I'm not sure if there's a ton of traction that can be gained here, and whether you see this as a potential way to combat these, to combat Dobbs. But I wonder if you have any thoughts about this, since I think this is squarely within your area.
Yes, we've been working on this for years, and talking to advocates at the ACLU and the National Women's Law Center and Center for Reproductive Rights and others about using religious liberty claims on our side. The First Amendment's religious liberty protections are necessarily neutral. They have to protect every faith tradition, every form of religious practice, not just those of right-wing evangelical conservatives. Although that's who's mostly brought cases and won religious liberty claims in the Supreme Court. And part of why that's the case is that the right wing has an enormously well-funded litigation machine housed in several nonprofits, Liberty Counsel, Beckett, the Alliance Defending Freedom, if I could put SICK in parens next to that term, the ADF, that they just crank out litigation constantly, raising religious liberty claims from the right, with arguments that 5 years ago we just thought were ludicrous. It almost risked, I thought, Rule 11 sanctions. They were so far outside the bounds of what seemed reasonable or permissible, and they are now claims that are embraced by the Supreme Court. So they've been extremely effective. We actually did another study at Columbia of the disparities in funding of religious liberty groups on the right doing advocacy in the courts and those on the left. And it's between 7 and 10 to 1 of the amount of money that's being spent on the right-wing side, the evangelical Christian side, to challenge all manner of, we're not talking only reproductive rights and gay rights, but wage and hour laws, union organizing, environmental health in the workplace, OSHA kinds of protections, domestic violence, child abuse. It's my religion to sanction my child with a cane and with violence because my God instructs me to do so. We have a report also on our website, All Faiths and None, that goes through some of this, and also another report called Parading the Horribles that goes through all of the places where right-wing religious liberty claims have been brought, in contexts like child abuse or domestic violence or even union organizing. But to bring it back to our side again, very briefly, Rabbi Silver in Florida has brought this lawsuit. I will say between us and 118 people who are on here right now, he has been strongly urged not to bring that lawsuit. He has no connections to the reproductive justice community in Florida. He has no connections to the people of faith who've been working on reproductive rights in Florida or nationally. The lawsuit is about him. It's poorly crafted and it's destined to lose. And he's been unwilling to take any kind of edits from us or others to strengthen that lawsuit. But there will be other lawsuits filed from groups like the National Council of Jewish Women, Catholics for Choice. There are groups that have been working on this issue for years as part of their faith practice, their ministry themselves. And they have very strong arguments. And we had a convening of people working on this issue not too long ago to talk about what were the risks and the benefits of bringing these cases, because we don't want to reinforce the Supreme Court's outrageous religious liberty jurisprudence right now. But we would also be, I think, it would be foolish not to use every tool we can to fight what's happening in state legislatures and in Congress. The right has been very good and completely not caring about risk in filing every kind of claim that they could think of. We're much more cautious on our side. We're much more risk averse. And maybe we need to be a little less risk averse. And I think these religious liberty claims are an example of where we can carefully bring them. Our recommendation is to do them in state court, not in federal court, using state religious liberty laws, which in some states are much broader than the federal religious liberty laws, but that might hopefully keep them out of the Supreme Court if we could. And you will see those lawsuits filed shortly. We're working with groups that will be doing that. If this federal or state court, these judges don't also respect progressive claims around religious liberty, but only conservative claims, then we've got a real problem around the separation of church and state, the ways in which our state and federal elected officials are actually embracing a particular theological idea of when life begins that in principle should violate the Establishment Clause, but there's two other cases that came out this term that basically erased the Establishment Clause from the First Amendment, and those are quite troubling. I'm happy to talk about them too, but I'll stop for now.
Well, I would love for you to cover that briefly, because I'm actually seeing a couple of questions that kind of get to that topic. So I think the audience may appreciate you to touch upon that. Okay,
just super briefly. So there were two cases, one having to do with flying a Christian flag by the city of Boston. There was a request that Boston would fly different kinds of flags. People asked that there be a Christian flag with a cross on it flown, and the city said no, because of the Establishment Clause. We'll allow a whole range of flags to be flown, but not those that have a particular religious content, because of our obligations under the Establishment Clause to not entangle ourselves with religion, to create the appearance of endorsing religion. And this goes back to the Supreme Court's Lemon test of what the Establishment Clause requires from public entities in terms of distancing themselves vis-a-vis religion, and also being neutral vis-a-vis religion. And so the Boston lost that case. And then we had Kennedy versus Bremerton, probably you all read in the paper or even read the decision, of a football coach who prayed at the 50-yard line after every game and thanked God for showing up in whatever way God did to help their team. And the city said no, or the school, it was a public school, you can't do that because it looks like while you're on the job, you are delivering a religious message that violates the Establishment Clause. We can't have that. In both of those cases, what the Supreme Court said is that to disfavor religion out of compliance, you believe, with what the Establishment Clause requires, which is to create some distance between the state and religion, is to discriminate against religious messages. So what it did is it kind of collapsed the space between the Establishment Clause and the Free Exercise Clause, and said that they almost went as far as to say any purported compliance with the Establishment Clause amounts to now discrimination against religion. So that if you're going to allow secular messages, let's say, vets for, Massachusetts vets want to hang up a flag in the Boston town hall, city hall, then you have to allow religious messages. Otherwise, you're discriminating against religion. And this is part of what we've seen in the court's religious liberty doctrine over the last several years that really came to fruition in the COVID cases, where the right wing really exploited and saw the COVID cases as an opportunity, where mass gatherings were limited, churches were shut down and had to go online, things like that, in-person gatherings were limited, and they were all challenged by communities of faith. By and large, the court embraced the religious liberty arguments there. And if the public health isn't a good enough reason to say religious gatherings have to be treated the same as going to Walmart or whatever, Target, then reproductive rights are never going to be strong enough. And that was what worried me in those cases. But what the court's done in these religious liberty and Establishment Clause cases is invent an equality right in the Free Exercise Clause that we've never seen before, in this sense that you have to treat religion as well or better than you treat any other secular interest. And the new standard of equality that the court now has in the Free Exercise Clause is so much stronger than the equality protections in the Equal Protection Clause around race or sex or other forms of protection. So as they're diminishing what it means, what the equality protections in the Equal Protection Clause are, they're expanding what equality means under the Free Exercise Clause. And so we need to kind of see all these as in an ecology in relationship to each other.
Thank you for that, Professor Franke. Going back to, I think it was you who said using all of the tools in our toolbox, I wonder if either you or Catherine could speak to the use of state ERAs to support the reproductive rights, either in the context of abortion rights or also just other healthcare issues on a state level. I know that this is part of your work, Professor Franke, but I'm sure, Catherine, you have thoughts as well.
I do have thoughts, but I would like Catherine to go first, since I don't want to take up too much space.
No, I think to be even as well.
Yeah, no, I think you should go ahead, because this is another thing that you've done a bunch of studying on.
Well, we do have 24 states have equal rights amendments. New York legislature just passed a bill that will move an equal rights amendment to the ballot, hopefully in 2024. And thankfully, it's not just around sex equality, but it's race, sexual orientation, gender identity, pregnancy outcome, religion, a whole range of things. By and large, those ERAs were ratified in the states in the 1970s, when the federal ERA was also being debated. And they don't specifically reference abortion in their legislative history. But for those states that are considering ERAs now, and there are several of them, my hope is that the legislative history will very clearly reference abortion, so that a sex equality right will be understood to include rights, reproductive rights, in a way that would overrule the Geduldig decision that Catherine mentioned earlier, so that we're modernizing state constitutions to have a more modern view of what sex equality necessarily entails. There's a case in front of the Pennsylvania Supreme Court right now. We did an amicus brief in it, where the advocates in Philadelphia challenged the state Medicaid limitations on restrictions on funding abortion under their state's ERA. So we'll see what Pennsylvania does. In Minnesota, we just got this fantastic trial court ruling finding the denial of access to abortion to be a violation of sex equality, equal protection in Minnesota. We'll see where that one goes. And then we've got another state Supreme Court that just recently ruled the other way, that the ERA in their state does not include abortion rights, and reaffirmed the Geduldig kind of approach to the issue. So different things are happening in different states, but this is an underutilized possible source of protections for reproductive liberty and equality, really sort of honoring Justice Ginsburg's approach to this issue, which has always been that access to abortion and the full range of reproductive health care is necessarily a sex-based equality right.
Catherine, I want to switch gears a bit and go back to our discussion about the right to travel. We're hearing about laws that are being contemplated or passed that would punish someone who helps a person obtain an abortion in a state in which it is legal to obtain an abortion. And I wonder whether you have any thoughts about the viability of such laws that seek to reach outside of the hostile state to punish those helpers, and whether you think that there's some vulnerability to the right to travel, as I think you've alluded to.
Yeah, so here's the ironic thing, right? Is that this potential source of protection is itself sitting on unstable ground, right? The right to travel, the right to travel is another one of these constitutional rights with no secure home in the Constitution. It's been protected under the Privileges and Immunities Clause of Article 4, under the Citizenship Clause of the 14th Amendment, and under the Commerce Clause in various decisions. There have been not many decisions about this, in particular, not many decisions that deal with extraterritorial enforcement of a state's laws. And we have conflicting doctrines and statutes out there. So on the one hand, we have Supreme Court decisions. I think the most recent one is Sens in 96, but older ones as well, that strongly suggest that a state in particular cannot enforce its criminal laws outside of its boundaries, And yet we have doctrines that go the other way, right? There is a judicially made doctrine called the effects test, which asks whether a resident's conduct in another state will have effects within the state of origin, within the home state. And if so, then the state can enforce its laws as against that conduct. So the most extreme examples are going to be in states like Georgia and Arizona, which have passed or are passing fetal personhood provisions. Because if the fetus is a person under state law, then abortion is murder. I just want to take a minute and make sure everybody understands this distinction. Abortion can be criminalized as a separate crime. Abortion is a crime and punishable only in the provider and not in the patient. You see these kinds of bans all over the country. But if a state designates a fetus as a person under state law, then abortion need not be criminalized as a separate crime, because now the killing of a fetus is murder. And I think there would be a serious constitutional question as a matter of equal protection under that state's law, whether you could separately punish it, distinctively punish it, and not punish it as murder, right? Why, if a fetus is a person, doesn't it have the right to the protection of the homicide statutes, as opposed to lesser penalties under the abortion laws? So in those states, I think that there are going to be arguments that essentially go like this: you're taking another citizen of our state, that is to say the fetus, outside of our state to kill it. That has to be punishable in our state, right? So I think the bottom line here is, I think that, I don't mean to overstate this, I think there will be significant pushback on attempts to exercise extraterritorial jurisdiction. But I also think there will be very creative and potentially successful efforts to exercise extraterritorial jurisdiction, and we simply don't know what's going to happen with those. On the one hand, we know that the congressional bill that aimed to protect the right to travel failed in the Senate, having passed the House, failed in the Senate. And on the other side, we have two kinds of things happening in the states. We have states like Missouri, which has now twice tried and failed, I want to emphasize that, to pass laws that would punish Missourians for having abortions outside of Missouri, or would punish doctors for providing abortions, would be the better way to say it, to residents of Missouri. Now, Missouri is a state that has virtually no abortion practice already. But about 10,000 people a year from Missouri seek abortions in other states. And what Missouri is trying to do is punish the people helping them. And they have twice now proposed laws that would do that and failed to pass them. But to give you a sense of how those laws were constructed, the first one was a criminal ban that purported to reach any conduct occurring partially within and partially outside the state of Missouri. And that was aimed at, you took the second abortion pill in Missouri, right? And here was the other things it purported to reach. The pregnant person resides in Missouri. There's a substantial connection between the pregnant person and the state of Missouri. The unborn child is a resident of Missouri at the time of conception. I'm not sure what that means, but I suppose it means that the egg was fertilized in Missouri. The pregnant person intends to give birth in Missouri if the pregnancy is carried to term. And the individual had sex in Missouri that may have conceived the pregnancy. So you can see, right, that's everyone from Missouri who's seeking an abortion. And it purported to criminalize providing an abortion out of state to all such people on the basis of these supposed connections to Missouri. Now, again, it didn't pass, and I think it would meet very, very significant constitutional challenge if it did pass. But we're going to see all kinds of attempts to to reach outside of states' boundaries and pull this kind of conduct within the enforcement powers of not only the states, but the citizens of those states through these bounty hunter laws, right? On the other side of the equation, you have states, also, I should say before I leave Missouri, that 2 Texas cities have passed ordinances. The cities of Cisco and Slayton, Texas, have passed ordinances that purport to prohibit abortions performed on their residents, no matter where the abortion occurs. Okay. On the other side, you have states, including, for instance, Connecticut, New Jersey, and New York, which have passed statutes that are aimed at protecting providers who are performing abortions on out-of-state patients. And those laws typically do a couple of things. One is they prevent public actors in those states from cooperating in investigations by the state where abortion is illegal into a legal abortion performed in the state where it's legal. So what you want to think of here is Alabama abortion patient is treated in New Jersey. Alabama district attorney or county prosecutor sends a subpoena saying, tell me every woman from Alabama who's been treated in your abortion clinic in New Jersey. That subpoena out of Alabama, New Jersey won't cooperate in enforcing it. And that means that the provider need not answer that subpoena because you can only answer it if the New Jersey courts enforce the order. So non-cooperation in investigations and also extradition protection for people who perform abortions in states where they are legal. And that protection runs to all the states except in the circumstances covered by the Constitution of the United States, which has an extradition provision, and which states that if you commit the alleged crime in a state and flee that state, physically, you have to be physically present in the state and commit the alleged crime in that state and then physically flee that state, then you can be extradited to the state making the request. So we're seeing attempts to protect people in treating people who travel on the other side. And those too, I suspect, will be subject to various kinds of challenges about whether a state is free to refuse to cooperate, for example. So my own view is that this is a very unsettled area of law, and that, you know, one of the things that's so, I don't know what the right word is here, like pathetic, I guess, about the Supreme Court's like, we're out, right? The majority and and in particular, the Kavanaugh concurrence are like this, we're out, we're out. We didn't like being in the abortion game, we're out. We're not doing it anymore. And like these cases are on an express train to the Supreme Court about what the various jurisdictions of the states are. And that's not even to mention if the feds get into this game and try to either restrict or protect travel. So that is a very uncertain answer, but I think it's a very uncertain area of law.
If I can just add one thing, as Catherine was speaking, you know, I'm a historian of race in the US, among other things. The parallels to the Fugitive Slave Act and the parallels to Dred Scott are overwhelming. The idea that the home state would define the legal identity of a Black person as a human or property. And then the home state would define the legal identity of a fetus as a person or not, are exactly parallel, that we would have bounty hunters running around the country, snagging pregnant people or people who've terminated a pregnancy, are exactly what we saw with the Fugitive Slave Act. The idea that there would be extraterritorial reach of laws legalizing slavery was what the Fugitive Slave Act ratified, and on a federal level, even though there were states that were resisting that, to be sure. And so we're going to be back into 1850 if we're not already. And then the irony that it's Missouri, which was the state at issue in Dred Scott, that is seeking to pass laws that look exactly like what the Scott family was contesting in the 19th century is also shockingly similar. And so those histories, I think, are extremely important, particularly when we start looking at the demographics of who's going to get prosecuted. I mean, I think we can expect that it will be Black and brown women who will be most vulnerable to criminal prosecution, because that's what we do in this country. And so the connections between slavery and what's happening now, I think, are undeniable and heartbreaking.
I mean, I agree with all of that, but I also think it's really Black and brown providers who are going to be the ones most likely to be prosecuted, because the optics of prosecuting women are not ideal for the other side, and the parallels to the Fugitive Slave Act there are also eerie, because what it means is, right? I mean, I'm been talking to providers, right? What it means is not only can they, so if a provider in New Jersey is protected from extradition based on providing abortions to people to patients from states where it's illegal, what happens when they leave New Jersey? They say to me, what happens if I'm driving to Florida? Answer, any of the states between here and there could extradite you if there's a warrant for your arrest in Alabama. For sure, you can't go to Alabama. But can you also not go to any state that, if they picked you up on a traffic violation, would extradite you to face charges in Alabama? Well, yeah. And that's exactly parallel to the Fugitive Slave Act. The way in which it's going to restrict the travel of abortion providers throughout the United States is just symptomatic of how we are not one country under this kind of regime.
I want to say that this has been an incredible discussion that we've only scratched the surface of. There were many, many questions, as you both know, that we didn't get to, and there are such wonderful questions in the chat that we're not going to get to. I want to say to those in the audience, the virtual audience, that we are going to keep those questions, and we're going to try to create another program where we can touch upon some of the subjects that you've been asking about. We did intend to talk about infertility treatment and IVF, and we just didn't have time to do that. But I want to be respectful of everyone's time, including the speakers. And so I want to say thank you so much for your time, both Catherines. This has been incredible, and there's a lot to think about. There has been a request for a reading list. So all of the cases that we've been discussing, I'm going to try to put together that reading list. And there's, of course, the articles that you sent around, Professor Franke. And I think that, if there are any other questions, I do invite audience members to email me directly at jdelgado@lowenstein.com. You can send me your questions if you didn't get to put them in the chat function. And we will try to put together another program, because we are committed to doing that in the Women in Law section. And I think this is a really, really important start. Thank you all so much for coming, and for Catherine and Professor Franke for your time, which we know is very valuable.
Thank you for having us. And I will just say that there is an article. It's long, but it's a heck of a cheat sheet on the issues that have come up, that was cited in the dissent in Dobbs, called The New Abortion Battleground. And it runs through many of the issues that are going to arise in the post-Dobbs world. If anyone wants a cheat sheet, it is still in draft. It's going to be published at Columbia, I think, Professor Franke, right? Mm-hmm. But it's available through SSRN online.
Thank you so much for inviting us to this hugely depressing conversation.
Thank you all so very much for your expertise, for sharing your time and your knowledge and your information. It was really great. I'm glad this was recorded, because I definitely will have to go back and listen a few more times to absorb everything that you were able to share with us today. And we really appreciate it. And for everyone out there, we will be doing more programs, so please keep your emails and your eyes and ears open for the programs that we'll be running as these issues develop, as new topics come up, as the same topics need to be, delved into and explored in so much detail. So thank you so much.
And just echoing Cheryl's comments, we'd like to thank today's panelists for putting on such a terrific program. This does conclude the webinar. Please make sure to return to your My Learning dashboard and complete the course evaluation. Thank you again for choosing New York State Bar Association programs, and enjoy the rest of your day.
Take care, everyone.